Welcome to the Probate Nation. My name is Richard Ruddy and I'm the host of the show. As a senior ages, they often need assistance in handling their financial affairs. This assistance can be provided in essentially three ways. Informal assistance, which works so long as the senior is able to make decisions, write checks, travel to the bank, personally do what needs to be done, and the like. There's formal assistance that can be provided by executing a durable financial power of attorney, thereby giving someone the authority to handle your financial affairs. And finally, there is the very formal assistance. This is provided by having someone appointed by the court to be the conservator of your assets. A conservatorship is costly to establish, and there are ongoing annual costs and court oversight. But that court oversight, coupled with the surety bond required of all conservators, provides great protection against conservators who might act improperly. A durable financial power of attorney, on the other hand, is a much less costly way to get needed assistance. Plus, a POA is particularly helpful when a senior's physical or mental incapacity eliminates informal assistance as an option. But while the POA is highly recommended as a document in estate planning, there are two drawbacks. There is no ongoing court oversight, and your agent serves with no surety bond to ensure their conduct. The absence of these features does create an opportunity for self-dealing mischief by your agent, and that mischief frequently results in costly and time-consuming litigation. Our show tonight begins a discussion of how financial powers of attorney are abused and the remedies to address these abuses. To get the discussion started, we are pleased to have two experienced Virginia attorneys who deal with these issues every day in their offices and in the courts across Northern Virginia. Our first guest is a partner in the Alexandria law firm of Dingman Labowitz. She's a graduate of George Mason Law School. Her practice focuses on guardianships, conservatorships, fiduciary trust, and estate disputes. Our second guest is a native of Fairfax and a graduate of the University of Virginia Law School. After law school, he clerked for Judge Albert Bryan in the U.S. District Court in Alexandria, and in 1979 he co-founded the Fairfax law firm of Blankenship and Keith. He is a civil litigator with an emphasis on trust and estate litigation. Among his many professional activities, he served as president of the Virginia State Bar from 1998 to 1999. Please welcome attorneys Ann Heisman and John Keith. Guys, thanks for coming by today.
Thank you.
Pleasure to be here.
So we have a lot to go over, and I'm really pleased that we have such great talent to actually answer some of these questions that we came up with. John, we talk about powers of attorney as estate plans. We see those as an important part of the overall estate planning package people put together whenever they go do estate planning, whether it's a simple will or a revocable trust or whatever. But what is a power of attorney?
Well, in its most simple description is it's a contract. It's an agency contract in which the principal, the person making the power of attorney, appoints an agent to do things for the principal. Sometimes that they call them agents nowadays. In the old days, they call them an attorney in fact. Mm-hmm. But that's the essence of the power of attorney.
Okay. Now, are there different types of powers of attorney?
Yeah, there are certain variables. There's the one we think of the most often is a general power of attorney, which is by which the agent can do virtually everything for the principal. Mm-hmm. We also sometimes, we call it a durable power of attorney because at common law, the power of attorney would terminate upon the disability of the principal. Under the new act, durability is presumed. And finally, there's a special power of attorney, and a special power of attorney is one for a specific purpose, most frequently a real estate transaction. You give someone a special power of attorney to close your real estate deal for you when you're going to be overseas. And I guess the final variation is, although the power of attorney is generally effective upon execution, there's something called a springing power of attorney where it would become effective upon the happening of a certain event or at a certain time.
Okay. So there's a lot of nuances to a power of attorney.
Can be.
There certainly seems the case. And can you talk about some of the important considerations, because one of the most important thoughts you got to come up with is who's going to actually be granted this power as your agent. So what are some of those
Absolutely. I think
considerations?
that's probably the most important element of a power of attorney that your client wants to consider is who are they going to name as agent to make these financial decisions for you. And so it's very important to consider who you want to appoint, and if you want to appoint more than one person, which can be problematic sometimes, but oftentimes people feel that they want two children to act. Another consideration is the extent of the powers that you want to give your agent. Do you want it to be very broad and allow them to make gifts, for example, or do you want to keep it very limited to paying bills and maybe managing investments? Lots of considerations when executing these kinds of documents.
Okay. Now, tell me a little bit, and why are powers of attorney so highly recommended by estate planners when people come in to do their estate planning documents?
Well, it certainly avoids having to get the court involved, for example, in a conservatorship action, and it's less expensive than doing that, and it's something that you can control. And you can revoke a power of attorney, unlike a conservatorship that can't be revoked. And it allows you to make the decisions about who you want to manage your finances rather than leaving it up to a court.
Okay. Well, I think that's important because, and we're having this discussion as we sort of lead into the next topic. Virginia has adopted an act, John, the Virginia Uniform Power of Attorney Act. So what's the purpose behind having such an act?
Well, before the Uniform Power of Attorney Act was adopted, I think in 2010, we basically had a few statutes which related to powers of attorney, but one of the great things that this act does is it collects all of the law relating to powers of attorney in one place. And it addresses a number of subjects that are now basically established and nailed down. And they talk about the authority of an agent under a document. They talk about the powers of an agent. They provide limits on the power. There are some provisions in there which allow drafters to incorporate powers. So there are lots of good, common sense, useful material that's in there that's very helpful to the practitioner.
Well, that's very interesting, John. Is there some way under the Uniform Power of Attorney Act to monitor how the agent is using the power of attorney?
Yes, and that's really one of the best features that's incorporated into the Act. There are really sort of two different ways to go about it. A principal can ask the agent to indicate and disclose to the principal what the agent has done, when the agent has exercised his or her power. That also can be done on an informal basis without any court supervision by certain other individuals who have an interest in the affairs of the principal. And they can go back and ask for 5 years from before the date of the request. There's another provision which is slightly broader, which allows a broader class of individuals to make a request. There are people who are interested in the affairs of the principal, and they can petition the court. And then you have a court-supervised inquiry into the activities of the agent and disclosure of all of the activities.
Okay. Now, and I'm going to turn to you because we're drafting our power of attorney. Is there any way that the drafter can restrict some of these rights that John has talked about?
Yes, and the code makes it pretty clear that the power of attorney can restrict the rights that somebody might have to ask for accountings or things of that nature. And you just would want to be careful as the principal. There certainly might be good reasons to have those restrictions in your power of attorney, but need to understand then that someone else who's looking out for your interests may not be able to obtain these remedies if you've restricted that right in the power of attorney.
Well, and that's very helpful to know, and I think that's one of the concerns we have because we find people are restricted in seeing stuff. and now there's no really way to monitor whether there is an abuse or not. Well, let's talk about some of the common challenges and in the creation of the power of attorney itself. One of those is what they call lack of capacity. What does that mean?
What it means, if you were going to challenge the execution of a power of attorney based on someone's lack of capacity, you need to show that at the time they executed the document, they didn't understand the nature of what they were signing and the consequences of it. So it's the same as contractual capacity. Did they understand they were signing a power of attorney, and did they understand what it meant?
Okay.
It's a hard challenge to make.
So it's a difficult burden to overcome.
Yes, very much.
On the other hand, we see people who challenge these things claiming that undue influence was brought to bear on someone who created the power. Explain what undue influence,
Undue
how it
influence,
plays out.
right, and oftentimes people make the challenge on both lack of capacity and undue influence. But undue influence by itself, there's a couple different ways to achieve that. And the first is showing that there was a confidential relationship and then a benefit to the person, the agent, which would be, they've gotten money for themselves or their bills have gotten paid. You can also show it by showing weakness of mind of the principal, so someone who maybe is in the early stages of dementia, but then also a benefit to the agent, such as the gifts. And that's also a hard challenge to make, and you have to be showing it at the time that the gift happened or the activity happened. And sometimes people are challenging, 2 years, 3 years after the fact, and it's hard to do.
So it's important to keep in mind all these different facts about when things occurred and how their capacity was at that time as we go further on in this discussion, because that will all come out in the course of litigation. Well, John, Ann mentioned about the establishment of a confidential relationship, and that's an important thing. So tell me, what does that mean? What is it?
Well, there are all sorts of confidential relationships, but they are those sorts of relationships where the principal places a lot of confidence in the person that they're naming as their agent, or the person with whom they're dealing, parent and child, husband and wife. Certainly a lawyer and client, all of these are confidential relationships, and the confidential relationships give rise to a sort of a heightened sense of scrutiny of the actions which take place between the people that are in the confidential relationship.
So let's talk about what are the implications of a confidential relationship when we start talking about activities that have taken place,
right,
that we're going to challenge.
Well, as Ann was saying, when there's a confidential relationship, that sort of gives rise to a presumption, and the presumption is that if there's an action that's taken by the agent, the person in the confidential relationship with the old person or the principal, it is presumed to be fraudulent or invalid, and therefore the person who is taking the action has got to overcome that presumption and show that everything was on the up and up.
So that's important for folks to understand, that once they're in that confidential relationship, they get under a heightened level of scrutiny, and they really have to justify and support everything that they've done. Let's take a look at some of the common abuses of that confidential relationship. So, Ann, let's talk about what are some of those common abuses?
Well, there's really the blatant ones, which is just having the principal write a check to you for your own personal needs, and that's not allowed under the terms of the power of attorney. Some powers of attorney allow for gifts and things like that, and so there can be a real question as to whether that was an abuse of the power of attorney. Taking the person to the bank and having them withdraw money, or using the power of attorney to change a beneficiary in a retirement account, for example, using the power of attorney to change the nature of an asset, put it into a trust, as opposed to having it remain individually titled. A power of attorney gives an agent an awful lot of power, which is why you want to be careful about who you select. But there's different ways that you can abuse it, depending on what kind of assets the person has.
But let's talk about some of the intended uses of a power of attorney. And why don't you talk about because there are good reasons
Absolutely,
to have one.
and having someone that can pay your bills and manage your investment account and make required minimum distributions from your retirement accounts, sell real property, that's a real value. Certainly there's a lot of good uses for powers of attorney, and most powers of attorney work fine. But I would say it's usually for paying bills and making sure that the property, whether it's an investment or real property, is being managed.
Okay. Now, John, what are some of the common abuses that you see with folks who use a power of attorney? Ann mentioned a couple, but what else have you been seeing?
Well, I think that taking most people that have this type of responsibility will do thousands of things right, but they will often do one thing that's wrong. And so when they're being scrutinized, usually by their siblings, they or other people interested, they will find one thing wrong. It can be a respite trip where you send yourself at the principal's expense to a resort to rest up from all the care you've been given the old person. Mm-hmm. They're so benefiting when the agent benefits himself or herself. That's one, and of course there's outright theft, which happens under limited circumstances. Usually it's a kind of a close call, but it's something that the agent really doesn't want to tell his brothers and sisters about, and they have to drag it out of them, and when they do, then that's the kind of thing, and it happens with some frequency.
Now, John, that being said, we'll go down that path. What are some of the common explanations that you've heard from people as to why they think that they're entitled to do what they just did?
Well, the most frequent one is that I had a detailed discussion about this with Mother, and she made it very clear to me that she wanted me to have this. She wanted to pay my children's college tuition, and she was adamant about it. I tried to talk her out of it, and the fact that they're operating, that they have a power of attorney, and that Mother is lost her ability to make these decisions wisely is lost in the process.
And what are some of the common techniques, forget about power of attorney, way people work around the powers of attorney,
right,
and do bad things?
What I see most often is someone either having the parent write a check or sign a check that they've written out to them, and so there's no power of attorney, there's not even a joint account, it's just, I need a check for the private education or my kid's orthodontia bill, and Mom, you go ahead and sign it. Mm-hmm. And I also see adult children having their mother or father add their name onto a bank account, and it's a joint bank account now, whereas before it was individually titled. That's what we see the most. Or just taking them to the bank and having them withdraw cash.
Oh boy. Well, that's very interesting, and we do see that all the time, unfortunately. So let's turn though to the lawsuit remedies that we would then pursue in order to recover. So we're kind of going to do this in kind of a shotgun fashion because we have a lot to cover here. So Ann, talk about fiduciary duty, breach of fiduciary duty.
So fiduciary duty normally arises as part of a confidential relationship, and for our purposes, principal and agent, and a breach of that would be using that power of attorney for the agent to benefit himself outside the terms of the power of attorney, writing checks to himself, writing checks for tuition for an adult grandchild, something of that nature. Okay. Using the power of attorney for the benefit of somebody other than the principal.
Okay. How about undue influence? How would that be claimed under the?
Well, it could be that someone has unduly influenced their parent to actually execute the power of attorney, naming them as agent. We certainly see that a lot, where the parent has done a power of attorney previously, but favoring one child, and another adult child decides that really they should be the agent, and then they will unduly influence the parent to name them as an agent in a document.
So that goes to the heart of the actual document itself. John, conversion. One of the theories.
Conversion is really nothing more than stealing. It's taking something that someone else has a right to and making it yours.
Okay. How about actual fraud?
Well, actual fraud is in this context of powers of attorney, probably tricking someone into signing a document they shouldn't sign. It's made by a misrepresentation of a fact that you intend for them to rely upon.
Okay. And constructive fraud?
Construction fraud is different only in that it's not an intentional misrepresentation. It's a negligent misrepresentation.
Okay. And Uniform Power of Attorney Act, there's a whole host of potential grounds for recovery. Duties, can you talk a little bit about that statute?
Sure, and there's a duty to disclose records. There's a whole laundry list of people who can obtain records from the agent. There's a number of, duty to act in good faith, duty of loyalty, and the first step would be asking the agent for an accounting of what they've done, and then potentially asking for return of assets that were wrongfully taken and attorney's fees under some circumstances.
Okay. So lack of capacity really comes up in the context of actually executing the document itself.
Yes,
Talk a little bit about
and then
that.
not the person just not understanding what they signed.
Okay. Now you talked about, when we were preparing for this program, about joint accounts.
Yes.
And the various nefarious conduct that can take place with that. Would you talk a little bit about that?
Sure. I think that some people, rather than, because they know there's some oversight for powers of attorney, they'll have their parent or disabled sibling add them to an account so that it's a joint account. But there's a statute that provides for remedies, just like with powers of attorney, and you have a fiduciary duty to a joint account holder the way that an agent would have towards a principal.
Mm-hmm.
So you can get a lot of these similar remedies, even if it's just a matter of using a joint account for nefarious conduct rather than the power of attorney.
Okay. Well, John, we're talking about different theories that we can pursue in order to recover and make things right. But what's the burden of proof? And talk about what that is. What do we have to show?
Well, I think the most interesting aspect in this context is the shifting of the burden of proof when you have someone in a confidential relationship. If I can prove the confidential relationship, then you have to prove that you haven't abused it.
Okay, that's very important.
Yes.
Because that burden can be sometimes difficult to meet.
Right.
Sure. Well, before we get too far along, let's really talk about, we've been talking about a lot of bad things that people do, but as you mentioned, John, a lot of people are trying to do the right thing, and they might make one misstep. Okay, so Ann, why don't you start and talk to us about some of the things that people can do who are trying to do the right thing in order to protect themselves in case they're being challenged down the road as they write checks for whatever the reason might be, including checks for themselves, if that was what they were going to do.
Right. Definitely keeping good records and having receipts matching up with checks. I think that's very important. And I think if you have other family members, so other siblings, you're the agent, if you have other siblings, being transparent about, well, this is what mom asked me to do, and I want everyone to know this is what I'm doing. I think those are two really important ways to protect yourself as an agent.
Okay. John, any thoughts about that?
I think the number one safeguard is to name only one agent at a time. People think if they have 3 children, that they need to make all 3 co-agents so they won't hurt anyone's feelings.
Sure.
And that gives rise to a huge number of problems. So my advice is pick the best one for the job and name that one, and you may name the others as successors if you wish.
Okay. Well, we've covered a lot of material, and we're running out of time, so I think I would like to get some closing observations and comments from you about this topic we've just covered, abuses of powers of attorney and remedies. Any final thoughts you want to share, Ann?
I would only say, just adding on to what John mentioned about choosing an agent, be very careful about who you're choosing, and it doesn't have to be a family member, and try to take emotion out of who your choice is going to be and really pick the best person. And maybe it's not any of your 4 children, maybe it's a family friend or a lawyer that you know. That's what I would advise.
Okay. John, anything else you would like to add? Some final words of advice?
I'd say maybe we're making this sound scarier than it is. I still think that the benefits of a power of attorney are huge, and people should be encouraged, everyone should be encouraged to have a power of attorney. Find that person in whom you have trust to handle things when you can't handle them. And I think when we sign estate planning documents, sometimes really that's the most important document. It's the one that's going to get the most play. And so it's an extraordinarily useful and important document.
Great. Well, Ann and John, thank you so very much for taking the time and visit with us today, share all this great information and all your experiences. It's a great service to all the people across Northern Virginia. So thanks again for coming in.
Thank you.
Thank you.
You're very welcome. With the aging of our population, we are seeing more seniors rely on friends and family to help them with daily living activities and finances. For the financial assistance, many execute a durable financial power of attorney, appointing an agent to act on their behalf. Others simply seek informal advice. Typically, a family member provides both the informal advice and in due course acts as the agent under a power of attorney. Unfortunately, not all informal advice or action by an agent is appropriate, and in fact, often that advice or action is really for the benefit of the family member. Our guests share with us some of the common abuses they regularly see in their practice, and they outline various remedies to address the abuse and the damages that might be recovered. All very helpful, especially their advice as to what not to do informally or as an agent under a power of attorney. I urge all family and friends helping a loved one with their finances, whether informally or through our financial power of attorney, to proceed with caution. Please get advice in advance if you will benefit in any way from actions you plan to take on their behalf. That advice will be well worth the cost incurred. This brings us to the conclusion of Part 1 on durable financial powers of attorney, abuses, and remedies. Hope you found it informative. In our next show, we will continue this discussion in Part 2 by examining the litigation process that unfolds as claims are pursued against persons who have abused their confidential relationship with the senior they are helping. Should be an interesting show, and I encourage you to tune in next week. On behalf of the Probate Nation, thank you for visiting with us.